Welcome, ladies and gentlemen, to this UKLFI webinar on the current property dispute in Sheikh Jarrah. We are convening in truly troubling circumstances as Israel continues to suffer under bombardment from Gaza, and the toll of those killed and injured continues to climb. Our thoughts are with all of the innocent victims and their families, Israelis, Palestinians, and foreign nationals. And we lament the futile loss of life caused by Palestinian terrorist groups from Gaza. It is important to acknowledge that this is not some spontaneous escalation, rather a planned escalation by Hamas in light of internal Palestinian power struggles. And Hamas has been stockpiling missiles and rebuilding its terror network with Iranian backing since the last conflict in 2014. In the context of this terrorism, much has been made for political reasons of, especially in recent days, of the property dispute in Jerusalem's Sheikh Jarrah neighbourhood. Israel's critics have distorted the facts, perverted international law, and adopted a bigoted approach, attempting to intimidate court and law enforcement officials into demanding that the state defy court orders and deny property owners their legal rights on the basis of the race of relevant parties. Now, the current dispute in Sheikh Jarrah involves several properties, and the litigation concerning them has been the subject of decades. It has gone all the way to the Supreme Court. I am tremendously grateful to have with us from Jerusalem Professor Avi Bell, Professor of Law at the University of San Diego and at Bar Ilan. He teaches both property law and international law. He is widely cited in those areas and frequently writes about the Arab-Israeli conflict. He is also a senior fellow at the Kohelet Policy Forum. Now, please, ladies and gentlemen, put your questions into the Q&A function on your screen. We will be seeking to answer as many of them as possible in the next hour. I've already had several sent in advance, and we will begin with those. So, Professor, welcome. And please, could you begin by explaining what this litigation is about?
Thank you very much for having me. And I will do my best to explain the litigation to the non-property lawyers among you. So what we're talking about here is 4 different lawsuits that have been combined. They're by a single owner. The owner of the property is a corporation called Shimon. There are 8 different defendants in the 4 cases, but all of them concern property that, as you said, is in the Sheikh Jarrah neighborhood. Now, one thing we have to understand is Sheikh Jarrah was not originally one neighborhood. It was created, the neighborhood was created in the 19th century. Until then, it was empty land. It had several graves that were pilgrimage sites, but no housing. In the 19th century, 3 different neighborhoods were formed there right next to one another, all in proximity to the relevant graves. There was an Arab neighborhood called Sheikh Jarrah and 2 Jewish neighborhoods, one called Shimon and one called Shimon haTzadik. Now, this property was in the Jewish neighborhood of Shimon haTzadik, right next to one of the pilgrimage sites, well, not right next to one of the graves. And it was purchased in 1875 by 2 rabbis and placed in family trusts, 2 different family trusts. This is this went on until 1948. In 1948, the country of Transjordan, which later became Jordan, invaded the newly created state of Israel, captured half of Jerusalem, and took over all the Jewish neighborhoods in the areas it occupied, destroyed them completely, expelled all the Jews, and handed over land of Jews to, or land of Israelis, to the custodian, the Jordanian custodian of enemy property. And so this property was sequestered by the Jordanian custodian in 1948, and it remained under the custodian's sequestration until 1967. In 1967, of course, the Jordanian occupation ended with the 6-Day War, and the Israeli official receiver took possession of the property of the Jordanian custodian. In 1970, Israel passed legislation ordering the receiver to release all sequestered property that had not been had its ownership transferred to someone else. All sequestered property should be returned to its owners. In this case, that meant the two family trusts. And in 1972, the family trusts went through the proceeding of getting their rights registered, their ownership registered. And that began 50 years of litigation. Now, we could go through all the various ups and downs, but the bottom line of all the litigation was that at every level, in every case, the ownership of Nahalat Shimon and its predecessors in title was upheld by the court. In most of these cases on the other side were a group of Palestinian families that had received leaseholds from the Jordanian custodian of enemy property. A 1982 settlement between the owners and the tenants agreed that this side had leaseholds, that side was the ownership, and the leaseholds would be protected tenancies under Israeli law, meaning that as long as they paid rent and abided by the terms of the lease, they could never be evicted. Now, the problem, of course, is that the tenants never paid rent, and then they've engaged in all kinds of other violations of the leases. The 8 defendants in this case, 4 of them are children and grandchildren of those tenants, again, who have never paid rent or abided by the terms of the lease. 4 of them are simply squatters on the land. And so, unsurprisingly, when this latest round of litigation began, the owners were able to win eviction orders. They won them in the magistrate's court. They were appealed to the Jerusalem District Court. The Jerusalem District Court went through all the facts, again, upheld the eviction orders, and now it's waiting for the Supreme Court to rule on the defendant's request for leave to appeal. Now, I'm not sure how the court will rule on the leave for appeal, but I do think that it's highly unlikely that this will result in victory for the defendants. I think that given the record and the clear documentation, at the end of the day, the owners have rights to their properties and they will win the eviction order. And the only real question for the state of Israel, the only policy question, since the state of Israel is not involved in this suit, this is a private property lawsuit between the owner and 8 individuals. The only question for Israel will be, does it uphold the law and carry out the orders or refuse to do so?
Could I, in the first instance, pick up on the differentiation between leaseholders and owners? There have been a number of questions relating to the ownership rights of the Palestinian Arabs that are facing potential eviction. So could you clarify that distinction for our audience?
Yeah, I'm sure most of the audience is familiar with with leaseholds, with leases in generally. Where there's a landlord who rents out property to someone else, to a leaseholder, to a tenant. And we all understand that the split that this involves. The landlord keeps ownership of the property. The tenant has a temporary right of possession that lasts as long as the lease lasts. And all leases expire eventually. Sometimes they expire after a number of years that's specified in the lease. Sometimes they're continuing leases that periodically renew until one or the other side decides to put an end to them. And if they're a protected tenancy, they can never be ended by the landlord. They expire only when the tenant breaches the lease or when the tenant dies. If there's a possibility in protected tenancies of the children of the leaseholder continuing the lease if they lived with the tenant, but it can never go past the second generation. That's what a lease is. Now, in this case, it's fairly clear what the rights are because the owners have the deeds going back to 1875, and they've already demonstrated this by registering the property. The property is already registered in their names in the land registry. There are no competing ownership claims. I will say that it's interesting that in this case, the four squatters have produced a deed that they claim affects this property. They claim that in, I'm not sure of the year, I believe it's around 1998, they received a deed from someone named Ismail that covers this land. The problem is that whoever this Ismail might be, this doesn't fit in the chain of title. That is, there's no recorded activity of an Ismail purchasing the property or otherwise acquiring title. And they haven't produced any deeds showing that this Ismail, whoever he might be, ever had any title to convey. So it's an empty deed. It's the kind of thing that in American law schools you would refer to as a deed to the Brooklyn Bridge, right? It's a piece of paper that purports to be a deed, but it doesn't really convey title to anything. So there's no real question about title here. The tenants have been able to produce documentation from the state of Jordan, and those are standard forms showing that they had leases from the Jordanians. What's interesting is it appears that the tenants actually had an agreement that the Jordanian custodian would eventually transfer title to them. He was supposed to do it within 3 years, but he never did so. And they never enforced their rights in Jordanian court. And of course, the Jordanian custodian no longer has any rights in the property, so it's no longer possible for the Jordanian custodian to fulfill this promise. But if the tenants have a claim that someone has wronged them, the person who wronged them is Jordanian custodian.
And how would the situation be different had the Jordanian custodian transferred title to these properties?
Well, this gets to the nature of sequestration, what it means to sequester property. So sequestering is not unique to Jordan or to Israel. It's something that's found throughout the world. It's actually referred to in international law encyclopedias. It's a common practice in wartime for states to sequester property of enemy aliens, that is, citizens of the enemy states that have property within the jurisdiction. So there, for example, there's a British Trading with the Enemy Act. There's an American Trading with the Enemy Act too. It's copied from the British one. That says that all alien enemy property may be sequestered by a custodian for enemy property. The British used this widely during the World Wars. And so they seized practically every German piece of property they could lay their hands on. Not only in Britain itself, but throughout the empire. So that, for example, in the British Mandate of Palestine, there was a British custodian of enemy property who sequestered these properties. Now, the way sequestration works is that the custodian does not take ownership. The custodian simply has possession and the right to dispose of the property. So if the custodian has the right to give someone else ownership, but the custodian does not himself have ownership. Now, in the Jordanian case, the Jordanian law, by the way, the Jordanian Trading with the Enemy Act is the British law. It's simply carried over to Jordan after Jordan acquired its independence. The way the Jordanian law works is the Jordanian custodian had custody of this property. The Jordanian custodian could give title to other people. And regarding other properties, that's exactly what the custodian did. But the custodian didn't do it in this case. So the ownership interest of the original purchasers of the two family trusts that held ownership from the beginning, right, from those until 1948 and onward, that ownership was preserved. It was preserved by the actions of Jordan, not by the actions of Israel. And it was preserved because the Jordanian custodian never released the sequestered property to someone else, never transferred title. And so it simply carried through. What Israel did in 1970 was simply release custody. It didn't create ownership, restore ownership. The ownership was already there. It simply released custody.
And had there been Arab owners registered, those would have been recognised by the 1970 law and traced through.
So, certainly, and that's what happened with other properties, right? That is, I don't have the figures in front of me, but I believe that most of the property that was sequestered by the Jordanian custody was actually had its title transferred. And so in most cases, it's not a possibility for the Israeli authorities to have released it back to its owners. Israeli law, like everyone else in the world, recognizes that where the custodian transferred title, that transfer is good.
Now, there have been a number of claims that there are different rules at play here for Jews and Arabs, and a number of the initial questions are going to this issue. Comments here that this case might open a Pandora's box because it reinforces Palestinian claims for a right of return pre-49 to property in Israel. So are you able to comment on the distinctions here?
Yeah, I will begin actually with the right of return. Sequestered property doesn't give anyone immigration rights, right? And so if the conflict, when the conflict ends, and sequestered property is either released to its owner or sequestered property is otherwise disposed of, it doesn't grant anyone the right to enter a foreign state. Britain seized various German properties, as I said, during the World Wars. That didn't give anyone, any German citizen, a right to immigrate to Britain or to any other to British mandate or British colony. The immigration laws remain as they are, and so it has nothing to do with the law of a right of return. But in general, I can say that the Jordanian Trading with the Enemy Act is not the only act by which the countries involved in these conflicts have sequestered property. Israel also has a trading with the enemy ordinance. It's left over from the mandate. It was enacted by the British mandatory authorities, and it's still in force. In addition, both Jordan and Israel have means by which they can actually take title to property. There are various statutes that authorize eminent domain. And it's understood that those are different set of rules. And finally, in Israel, there's something called the Absentee Property Act, which sequestered properties that were abandoned by fleeing parties during the war, and some other properties that are more or less similar to enemy properties. And it's sequestration like every other kind of sequestration. It's held by the custodian pending the end of the conflict. Now, for all of these cases of sequestered properties, I can say that the treatment of Israel has been more or less the same. I can say that none of the relevant laws distinguish on the basis of ethnicity. So for all of the relevant laws, Jews and Arabs get treated the same. The claim that somehow or another there's some differential treatment based on whether someone's Jew or Arab in Israeli law is simply false. In all of these cases, the sequestered property went to the custodian, where it went to an Israeli custodian. In some cases, it was released to the original owners, but in most cases, as with the Jordanian custodian, in most cases, the Israeli custodian transferred title. And so at some point, when the conflict is over, there will be property claims that Israel will have to deal with, which will be compensation claims. The original owners who've now lost title because the custodian transferred title to someone else will have valid claims. By the way, Israeli law recognizes this. They will have valid claims that they will be able to recognize, to present for compensation. And again, this doesn't make a difference whether they're Jew or Arab, Palestinian or Israeli. The one unique item here is that the Israeli parliament ordered that all the properties that were held by the Jordanian custodian of enemy property be released. And there's a very simple reason for that. And that is that the Jordanian custodian was holding them because these were properties of citizens of the enemy state of Israel. And it would be bizarre in the extreme if the Israeli receiver would hold these properties on behalf of Israel until the state of war, the conflict between Israel and Israel ends. Right? It's simply an absurd proposition. And so it makes perfect sense to have ordered the release of all of those, because that conflict, right, the conflict between Israel standing for itself and Israel's standing in the shoes of Jordan is over, right? All the rest of this, that when the conflict is over, there will be property issues to work out, and everyone will be able to raise their claims.
That's dealt with, I think, 5 or 6 questions on the absentee law. So thank you very much, Avi. We've got something framed as a basic question here. Under international law, whatever that is the land in question under the jurisdiction of Israeli law?
That's not really the kind of question that international law has an answer for. What I can tell you is this, that there is a claim made by critics of Israel that Israel, in applying the laws in East Jerusalem, is required to treat that area as if it were belligerently occupied land. Now, if it is belligerently occupied land, then the laws of belligerent occupation require Israel to respect the property rights of the people on that land. So if you think this is belligerently occupied land, I don't think it is, but let's imagine that it is. That's the claim of the Palestinians. If it is, then you get to the same result. Israel still is obliged to respect the private property rights of the owner here. There's no ethnic disqualification in international laws of occupation any more than there is in Israeli law or in any other international law. That's simply a fabrication of the anti-Israel propagandists. So they may claim, they may have this imaginary version of international law in which Israel is forbidden to recognize Jewish rights or required to discriminate against Jewish property owners, but that's not part of international law. There's just simply no such law.
Thank you. And that also deals with a question of if the claim by Jewish owners to these properties is upheld, how is this compliant with international law, given that they are located outside of the state of Israel and occupied territory? Well, even taking that premise, as you have done, it doesn't impact the individual property rights. And perhaps it's important to stress in this context the difference between individual property rights and state property and issues of politics that attach to those considerations. In that context, there are a number of questions of the role of the Israeli government, suggesting that it has been supporting the claims of Israelis in Sheikh Jarrah. Could you comment any further on that?
Well, this has been a matter of private litigation for nearly 5 decades. What the state of Israel has done is it has provided courtrooms for the parties to litigate their claims. The state of Israel has not been a party to the litigation. The state of Israel has not boosted one side or the other in the litigation. The state of Israel supplied laws that are neutrally applied to all and are exactly the sorts of laws you'd expect to see elsewhere. And frankly, other than the fact that Jordanian law discriminates against Jews, that is, it doesn't recognize the ability of Jews to hold and exercise property rights, this would come out the same way under Jordanian law. Right? There's nothing unusual about a landlord-tenant dispute or about a landlord-squatter dispute, and they all end the same way. Right? If the tenant is operating within the bounds of the lease, the tenant will win. And otherwise, the landlord will always win against a breaching tenant or against a squatter. Those are the rules everywhere. And that's exactly what's happening here. And there's no unusual involvement of the state of Israel. What you're really seeing, and this is bizarre and unfortunate, is that the Israel critics, That would be the mild way of putting it. Or I would say the anti-Israel propagandists, I think that's the more accurate way of putting it, are creating law willy-nilly to reach the result they want, which is that Jews have no rights and that Israel is always in the wrong. And they're more or less demanding that the state jump into a private dispute and exercise its authority to deny the rights of the property owners. And the only reason that they are asking that is because the property owner here is Jewish.
And in that context, what are we to make of the decision to delay the final ruling on this?
So what happened in the Supreme Court, the Supreme Court was supposed to rule on the request for leave to appeal on, it was actually supposed to hold a hearing, excuse me, not to rule finally, but to hold a hearing on the request for leave to appeal on May 9th. The Attorney General of Israel asked the court to delay the hearing, and the court agreed. And what you're really seeing, I think, is a very unfortunate success of anti-Israel propagandists in intimidating Israel's legal authorities. It's quite clear that they didn't want to issue a ruling immediately because they are afraid that someone might react violently. Or let me be more precise, that if they rule as the law requires them to rule in favor of the property owners, there was a clear and express threat of Palestinian rioters to take violent action. And so the court is postponing this to a later time when hopefully things will be quieter. And that means that they've been intimidated. I think that it's really, really unfortunate, but I can't blame somebody who bows to intimidation as much as I can blame those who are actually doing the intimidation.
I'd like to take you back, if I may, to some of the specifics of the dispute, because we've had a few additional questions on that. And one is whether we know, did the Palestinians pay rent to the Jordanian custodians between 48 and 67? Is that something that we have records of?
The records that we have of the Jordanian custodians' dealings with these tenants is very incomplete. For most of the time, we had no records at all. And Jordan only turned over records of the lease forms recently. The Jordanian government announced that this proves definitively that the tenants are owners. The forms that they turned over don't prove that at all. They actually prove that they're leaseholders, but they haven't turned over any other records. So we have no idea whether they paid rent beforehand. We do know that during all the years of this litigation, none of the tenants has paid rent.
And so on that basis, there's an additional question of why they agreed to pay for the lease in the first place. You mentioned in 1982 a court ruling recognizing a settlement agreement under which rent was to be paid. Do we have any indication as to why that agreement would have been reached if no rent had been paid up until then, and evidently there was little indication that there was an intention to pay rent going forward?
I think that the benefit to the Palestinian litigants, to the defendants in this case, or the predecessors to the defendants in this case, the benefit to them was that they got a protected tenancy, which meant that they could only be evicted if they passed away and their children didn't live with them, or their children passed away if they had lived with them, or they broke the lease. As long as they lived within the bounds of the lease, they could go on indefinitely in these properties. And that was something that's more than simply an ordinary lease. An ordinary lease, it terms up, you're gone. And so that was the advantage to them. And they certainly couldn't prove any rights beyond a lease. And so for them, this was a good deal, and they took it. Right? It was the best deal that they had available. That's why they signed the settlement agreement. It wasn't because they were feeling particularly generous. Now, this is actually, the settlement agreement was generous to them in recognizing the protected tenancy out of the lease documents. But at any rate, if they had if they had some problems with this, the time to think about this was back in 1982. One of the interestingly, it is possible to overturn such a settlement after the fact if you can prove that there was undue pressure or some other misbehavior that led to the settlement agreement. They haven't been able to do so. They haven't been able to show any misbehavior. There wasn't any, right? So if they wanted to try to overturn it, they could have tried to, right? They could have adduced proof of any kind that there was misbehavior. They didn't. There isn't any. There wasn't any.
Now, a point of clarification, perhaps taking you back to your opening remarks, there's a question as to whether the properties are in Sheikh Jarrah or in one of the other two suburbs you mentioned. Is it the case that there is a continuing distinction between these areas, or have they been amalgamated?
No, when Jordan occupied East Jerusalem, it wiped out all the Jewish neighborhoods. And Nachlat Shimon and Shimon haTzadik, which were side by side with the Sheikh Jarrah, were simply all combined into one big neighborhood called Sheikh Jarrah. And that's what Israel calls it today. It calls it Sheikh Jarrah. The Jews who live there prefer to call these areas Nachlat Shimon and Shimon haTzadik, but the municipality doesn't recognize those as separate neighborhoods today. They're all one big neighborhood of Sheikh Jarrah.
Avi, we have had about 3 or 4 questions asking why on earth it has taken so long. This is a process through the Minister Court, the district courts, reaching the Supreme Court. Is it simply the Israeli legal system, or are there other factors at play that has caused this to drag out for decades?
Israeli courts are extremely, extremely reluctant to issue eviction orders, even where it's absolutely clear that the tenants are in the wrong. And I can tell you this, among other things, from personal experience. I had the misfortune of handling a case for my family, for cousins in Tel Aviv, involving a tenant who was in breach of the lease. And it was a good decade long of litigation before we ultimately reached a settlement. Even though I think that the breaches of the lease were absolutely clear and no rent had been paid, by the way. It's in general a very long process. The Israeli courts bend over backwards for tenants, and they are doing so here. Among other things, Israeli courts continually prod the tenants that are in breach to resolve the breaches, come back into compliance, and the court will forgive their old breaches. So the tenants in this case have been repeatedly invited by the courts to pay up the rent, and then the breaches will be forgotten. And they refuse to do so. So there are lots of opportunities to fix things. Israeli courts are set up to defend them, to defend their rights. That I think is the reason this has taken so long. But let's also understand that part of the protected tenancy that they got is something that gave them the right to drag their feet out for many, many years. Protected tenancies are designed more generally to allow tenants to stay on for a very, very long time. So we know what's protecting them, what's giving the tenants here such a long period of time to go through a court is exactly the reason why they'll ultimately lose. It's because their rights are not infinite. Their rights are finite, but they last a long time.
Now, we've referred to many of the tenants collectively. There are questions here as to whether all of these tenants are in fact continually living in these properties, or are they absent tenants, and if so, are their rights in any way impacted by that status?
So one of the tenants here is apparently not in residence. She's got an alternative residence in Ramallah, and it's claimed that therefore she's no longer residing in this unit, she's residing in Ramallah. Now, what that means is that she gives up the tenancy. If you abandon the tenancy, if you're no longer using it as your residence, then the nature of the protected tenancy is that it's no longer in existence, right? So that would be grounds for terminating her tenancy. The court said that on that issue, it didn't need to rule because there were ample other grounds for terminating the tenancy, among them non-payment of rent. So it just it hasn't been litigated to the end. There are other allegations in the cases of unlawful subletting of the apartments to others, but again, the court didn't feel that it needed to go too far along that line because there were ample grounds for an eviction order without going into it.
I mean, there are those in the audience that I can see that say they are still puzzled by what is termed an abrupt dismissal of the relevance of international law. So perhaps we could take a moment to return to that. You've spoken about the application of the Geneva Conventions. You've also spoken about the operation of international law with respect to the issue of sequestered property. Are there any other aspects of international law that could impact on these proceedings? And if not, why is it that international law is being cited evidently wrongly as having relevance to this dispute?
All right, I'm actually going to take the long way around answering that. I want to give you an example from an entirely different context. I've been using this for the past few years just to give an illustration to people of how international works in public discourse. And it's a case about an archaeology conference. There was an archaeology conference that was going to be held by the Palestine Exploration Fund, which, by the way, is a British organization. It was going to be held in Jerusalem. They ended up canceling it because the organizer of the conference, the head of the Palestine Exploration Fund, an archaeologist not an archaeologist, a scholar actually of history, who recently passed away, a man by the name of Philip Davies, had rejected all submissions to the conference by Jews. And he wrote an editorial in his journal to explain why it was that he'd dismissed all submissions by Jews. And he said, listen, it wasn't me. It was international law that required me to do it. Because if you read the UNESCO Convention on, I can't remember the name, but it's 20 words long. If you read this UNESCO Convention, you will see that we cannot deal with the results in any way of unlawful Jewish excavations in East Jerusalem. Now, I've read that convention many times, right? And it says nothing whatsoever about papers and conferences. In fact, it doesn't even talk about illegal excavations. What it talks about is protecting items that are found in excavations. It talks about illegal trade of archaeological artifacts, which has nothing to do with what Davies did. So why did Davies write in this editorial that the reason he was discriminating against Jews was because international law required him to do it? And the answer, I think, is the same reason that everybody's convinced that international law is important here. It's because people say international law as the instant excuse for their discrimination, with the understanding that nobody in the audience will have a clear understanding of what is in international law, and they'll take it on faith that international law requires discriminating against Jews. And that's exactly what's happening here. And I may stop using Davies as my example and start using this as the example. I just, as much as I rack my brain, I cannot fathom what is the international law claim that critics of Israel are making here. There is, quite simply, there's nothing in international law that permits, let alone requires, Israel to deny private property rights of the owners here simply because they're Jewish. Now, there are those who say, well, it's because it's occupied territory. All right, if it's occupied territory, you still get to the same result. Israel's still required to respect the private property rights. There are those who say, yeah, yes, but these are settlements, and the Jews there are settlers. And those are terms, by the way, not found anywhere in the Geneva Conventions. There's nothing in the Geneva Conventions about settlements or settlers. There's a provision in the Geneva Convention that talk about transferring domestic populations. Now, there's no transfer here. There's no conceivable argument that international law forbids or requires Israel to discriminate against the property owners, lest Jews will move from somewhere in Israel to somewhere where they are renting or owning property in so-called belligerently occupied territory. These are just all imaginary arguments. They don't rest on anything. And so it's one of these impossible arguments for me, where I'm supposed to invent a provision of international law that Israel is allegedly breaching, and then explain to you why I think it's okay. I don't have any such provision. I can't even figure out what it is they're claiming that Israel is doing wrong. There just is no such provision of international law. I will add even the one thing that deals with this in all of the Geneva Conventions is an approval of sequestration of enemy property during wartime, and that you can see referred to matter-of-factly in the commentary, the official commentary on the Fourth Geneva Convention. I believe you can find it after Article 80, and the commentator says, well, of course, in the cases of conflict, most states sequester enemy property, and then it goes on and it moves on to another issue. And so it's clear that it's done and that it's perfectly legal to have a sequester. I don't have any idea what the other international law dimension is here that's allegedly relevant and requires Israel to violate the private property rights of the Jewish owner here.
Well, following on from that, there are a number of questions on the optics, and notwithstanding the fact that the law is with the owners, how this is being portrayed as ideological and political. So one of the questions that we have, given the explosive potential here, do you think it's sensible to persist with evictions when presumably, well, this individual presumes that the owners have no great need for the property? So are we meant, or is there an advantage perhaps in throwing property law and property rights out of the window due to the presentation of this issue, Avi?
Well, as we discussed before, we agreed to do this. I'm in Jerusalem right now. Every so often, I have to run down to the bomb shelter because of rockets that are being launched by terrorist groups in the Gaza Strip. They've done so notwithstanding the fact that the eviction orders, which were issued years ago, have not yet been carried out. The idea that somehow or another these terrorist groups will, say, "Oh no, never mind, everything's okay." If in this one case, the state of Israel will violate the property rights of the owners and squash their legal rights and the eviction orders they've received, I think it just defies everything I know about the conflict. I think that if anything, what you'll see is exactly the opposite. If the threats and the carrying out of this sort of violence forces Israel to abridge the private property rights of people simply because they are Jews, we are going to see threats and violence like that again and again and again. Now, as far as public opinion, I think that those who are inclined to believe Philip Davies that it's illegal to accept papers by Jews in an archaeology conference, or those who are inclined to believe that international law demands that Israel deny private people the right to enforce their property rights if they're Jews, those kinds of people are not amenable to rational persuasion. There's no point in addressing arguments to them. There's certainly no reasonable basis for discriminating against people and denying their civil rights simply in order to try to get these irrational bigots to recognize that something is wrong.
Avi, if you'll permit me, I think it's important that we be absolutely clear on the origins of this latest round of violence, and push back on the suggestion that there is any link to the private property disputes that you have been so helpfully addressing us on. If anything, the evidence is that this latest round of violence arises from a struggle between the Palestinian terrorist groups of Hamas, Islamic Jihad, and with Fatah. Now, an internal conflict between Mohammed Daif and Yahya Sinwar, sparked by Mahmoud Abbas's decision to cancel elections because he thought he wasn't going to win, when we note that he was in the 16th year of his 4-year term. None of that, of course, has anything to do with the property rights that the owners have in this part of Jerusalem. And of course, you and I both know that the month of Ramadan is usually tense due to extreme incitement by Arab leaders. Over the course of that month, we've been seeing attacks in Jerusalem on Jews randomly in the street, encouraged substantially over social media, which escalated very rapidly into the riots that we saw at the Temple Mount and now throughout Israel, unfortunately, in many mixed cities. Together with, of course, the rocket fire that you have mentioned. Now, this, of course, as I indicated right at the start, is planned. There were several suggestions that when this initially began on Saturday, the 24th of April, you will, of course, remember that 36 rockets were fired then, and there was strong advice from the military that the situation needed to be dealt with. In order that it didn't escalate. Israel's politicians opted for restraint, and we are where we are today. But the suggestion that any of this can be boiled down to the dispute that you've taken us through is something that I think those in the audience, those listening, now with a better understanding of what it is that is being dealt with in Sheikh Jarrah, will have hopefully future opportunities to push back robustly against. In that vein, we've got a number of questions on the international media, and one here says that there are reports of several hundred evictions. So is it correct that the case only involves 31 individuals? If so, why is this point not being made to the media? Well, I'm sure, Avi Bell, that you are making this point at every opportunity. But taking on...
If I may, no,
yeah.
Actually, if I may, let's understand that there are, this is not the only dispute between landlord and tenant in Israel. There are lots of such disputes. And among all these disputes, in some cases, the landlords are Jews and the tenants Arabs. In some cases, the landlords are Arabs and the tenants Jews. In some cases, they're both Arabs, both Jews. But there are other pieces of litigation out there besides this one case that we're talking about. In this one case that we are talking about, there are 8 defendants, 1 owner.
Thank you. And we've got forgive me, a follow-up question as to why this has necessarily erupted in the last few days and weeks. A question as to whether that is opportunism. I don't know if you've got any further thoughts on.
I most certainly do. I most certainly do. Listen, as you can hear, we're not talking about anything that's new. This is litigation that's been going on for decades. Right? And again, it's not simply this one case with the 8 defendants. There are lots of other property disputes. There are property disputes in Sheikh Jarrah. There are property disputes in the old city of Jerusalem. There are property disputes, everywhere the eye looks. Right? That's just the nature of these things, and they last a long time. And so we're dealing with right now a round of Palestinian attacks, the smaller ones, the ones that were involved mostly Arab kids attacking visibly Orthodox Jews, beating them on video and then distributing the videos by TikTok. Those are attacks that began with the beginning of Ramadan, and they were encouraged explicitly by Mahmoud Abbas, by the Palestinian Authority and the Fatah Party. And then the next round of attacks, the attacks where worshippers on the Temple Mount attacked Jewish worshippers down below in the Western Wall, where the terrorist groups in Gaza Strip started launching rockets, that began several weeks into Ramadan. And that was the result of Hamas trying to compete with Fatah over who's going to take a stronger stand against Israel. Now, none of this fits the narrative of innocent Palestinians rising up against oppressive Jews who are trying to push them out of their lands. And so none of that makes for a good media narrative in places like The Guardian or the BBC. And so they like a different narrative. And the narrative that they want is the narrative of Palestinians losing their homes. And so they've taken this case, dressed up imaginary facts around it, and placed it at the beginning as the cause of the terrorist violence against Israel. And the fortunate thing about this fake narrative is that at least one thing is true. The litigation in Sheikh Jarrah preceded the violence because it's been around for decades. And so you can always say that the violence is the result of this litigation.
I'm going to whiz through as many of the questions that we've had flooding in the last 10 minutes, Avi. A few of them are asking about media references to the property owners as settlers with therefore no right to own the property. So could you address the term of settler that has been used for these property owners? And separately, we've had a question as to whether the owners are Jewish or Israeli and whether that ought to make any difference.
Okay, so first about the term settler. I think I mentioned this already, but I will reiterate it. Settler is not a legal term, right? There is nothing in the Geneva Conventions about settlements or settlers. It's a political term. It's a political term that is in vogue among critics of Israel because it has this connotation of illegitimate residence. Right, the settler is someone who shouldn't be there. Right, we refer to the residents that we want to recognize their rights. We'll refer to them by their ethnicity or something else. Right, we'll talk about the settlers versus Palestinians. So, right, those who want to show that there's an illegitimate side and a legitimate side, but it's not a legal term. It doesn't have any meaning. Right. So are they settlers? I don't know. Since the term doesn't mean anything, it's really impossible to say. You know, it's like asking whether they are people of good character. I don't know. I haven't met them. All right. Now, in this particular piece of litigation, the owner in question is actually a single owner for these cases that are supposed to be before the Supreme Court. It is a corporation. It is the Shimon Corporation. I don't know who the owners are, except that I will say this. Shimon is a corporation that is a wholly owned subsidiary of an American corporation. The American corporation is called Shimon International and is registered in the state of Delaware. And the shareholders of Shimon International are unknown, except that we can guess by the name that they are Jews. Right? That's all we know about them. Now, there are other cases where we do know who the owners are, but in this case, that's about all that we know about the owners.
Taking you back somewhat, there's a question asking whether following the release by the Israeli custodian to Israeli owners, I think we might need to clarify the release of the custodian. Well, the question, and that is one that has been posed by a number of people, is why rent was not demanded from that time by the landlord. So do you know from what point rent was being demanded across the lengthy process that you've described?
Okay, so first just about the technicalities of this. How does this work, right? Again, so sequestered property is held by the custodian until after the conflict, and then release is discretionary. Okay. Now, in this case, the custodian of Jordanian property lost control of it in 1967 when the Jordanian occupation ended, and the state of Israel, pending resolution of the property issues, handed it over to the Israeli receiver of properties, who generally deals with bank properties of the bankrupt and the like, but in this case held the properties of the Jordanian custodian. And in 1970, Israel passed the law ordering the receiver to release custody to the owners. So it was the Israeli receiver who released custody to the owners shortly after 1970. And then at that point, the registration process began, where parties came forward to say, we are the owners, here's our proof of our ownership, here are the deeds, and went through the process of registering where their claims are published, and anyone with competing claims is invited to come and present their documentation. And then finally, there's a ruling on whether they can register or not. Now, the theory of these residents being tenants was new to the owners. That is, the Jordanian custodians' records were not handed over to Israel. The residents who were there did not clarify their status willingly about anything, and so the initial round of litigation was to evict squatters. And it was only after a long round of litigation on that question where the Israeli Supreme Court recognized the ownership of the registered owners, right, of the Jewish owners here. It was only at that point that the Palestinians came forward with the theory that, well, we're actually tenants from the Jordanian custodian. They didn't have any documentation at the time, but nonetheless, they reached a settlement agreement in which the courts agreed to create that status. Now, part of that status was they should not only have paid rent going forward, they should have paid back rent. They never paid rent, not backwards, not forwards.
Finally, perhaps we'll see how we do with time, that there is a separate issue that's been raised, and it's in relation to demolition orders for properties that are constructed without planning permission. And in relation to that, our questioner asks whether it's more difficult for Israeli Arabs to gain planning permission than Israeli Jews. Are you able to?
Well, that is a very difficult question to answer, and I'll tell you why. My impression is that it is difficult for everyone to get planning permission. It is difficult in the following sense, that if you have the rights under the relevant plans, it will take years to get the relevant license. But if you have the right under the plans, you will eventually get it in 100% of the cases. The cases that are more interesting is where you don't have rights according to the plans and you're asking for some kind of variance, right? You're asking for permission to build outside of the plans. Now, in those cases, it really depends on what sort of variance you're asking for. If you're asking for a variance to build a 10-story building where the plan permits 1 story, then it's unlikely that you're going to get a variance. Whereas if you're asking for the ability to expand your porch by 1 square meter, there's a much higher likelihood. So you can't really compare percentages without getting into the fine details about what is being requested. Now, the real truth is that in almost all cases in Jerusalem, and certainly if you go outside of Jerusalem to Area C of the West Bank, Arabs simply don't ask for building permits, and they don't. They don't because they're encouraged by, among others, the Europeans and the Palestinian Authority to not do so, because that would recognize Israeli authority. So they build illegally with the assurance that the Palestinian Authority or the Europeans will pay for the litigation afterwards for the prosecution. But there's vast amounts of unlawful construction, both by Jews and by Arabs. There are a very small percentage of the illegal construction that gets eviction orders. And so far as I have seen of the figures, the number of demolition orders is much larger for Jewish illegal construction than it is for Arab illegal construction.
Professor Bell, we've come to the end of our time together, but I am incredibly grateful, as I'm sure our audience, perhaps record numbers joining us for this session. It is a complex topic and one which is not being dealt with in any way appropriately in the media. I very much hope that, armed with your incredible in-depth explanation and expertise, those who have been watching, and I'm sure will continue to watch over the coming days and weeks, will be better armed to deal with the pressing questions and misrepresentations over this particular legal dispute. I say that I'm very grateful for your participation and for our audience. I hope they will join us for our forthcoming webinars. And in the interim, I wish you and everyone watching us from Israel a very safe and peaceful coming days. So thank you very much indeed.
Thank you, and thank you everyone for joining us.